And to everyone who's joining us today. And we are so delighted to have people literally from across the globe with us for this important conversation. We know that there are others who are going to be joining us over the course of this coming hour. And I think when we looked at the terrific registration list, we saw that we had individuals who had registered to participate in this dialogue spanning the globe, literally from over 20 nations around the country. And that's not surprising when we've come together to talk about a conversation and an issue that has really plagued this country, the United States, and other parts of the world for a long time without great reform or change having happened to the extent that I think all of us would agree is necessary. We know that just last month, a 15-year-old student was arrested and locked up and accused of being part of a shooting that he had nothing to do with. We know that he was held and questioned without parents, without a lawyer, and eventually told that he would be fed and allowed to go home if he confessed. And sure enough, he falsely confessed before it was determined that he had had nothing to do with that incident. So at Fair and Just Prosecution, with the tremendous and inspiring elected prosecutors that we work with around the country who are committed to trying to address concerns like that and make our justice system truly live up to that name, we are so pleased to be working with partners at Fair Trials who bring that same set of values to global reforms to set the table for this conversation. We know that as we sit here today, false confessions are the most frequent contributing factor in wrongful convictions. But practices that are based on coercion, that are based on deception, that are based on the types of strategies that children are particularly vulnerable and susceptible to continue to happen time and time and time again. Children are questioned without a lawyer, without a parent present. They're questioned using deception. They're questioned for hours on end. They're questioned in ways that can be deeply intimidating for the most experienced of adults, and particularly so for young people. We know that studies tell us that very often children will waive their rights and waive up their Miranda, so-called Miranda protections, something that they probably don't even understand, but they'll do so with no lawyer present or adult there to tell them the consequences of what they're doing. And we know that there have been far too many high-profile examples of kids wrongfully convicted based on false confessions. In fact, studies tell us that kids of all ages have falsely confessed in over a third of exonerations. And that if you look at that number for kids who have been charged with crimes and cases before they turned 14, 86% of those young people who were exonerated later for those crimes falsely confessed. We also know that this country is a global outlier, and Rebecca Schaefer is going to talk more about that. And we know that if we look at trying to promote a justice system that can keep our communities safe, that trust is critical. And these practices and perpetuating them necessarily erodes bonds of trust. This has to change. Some states are acting. We are seeing states that are outlawing use of coercion or deception, that are requiring lawyers to be present. Even one state that is making clear that below a certain age, you simply can't lawfully use the statement from that young person. At Fair and Just Prosecution, we are trying to guide what national reform can look like and should look like. And we've put out an issue brief with key principles and a model act that we hope will serve as a national roadmap for policies in prosecutors' offices, for policies that states should embrace. So we are here today to talk with this incredible group of experts and leaders about how we propel change, how we capitalize on this moment, and make sure that these things don't continue to happen every month, every week, every year. With us for this conversation is Nora Nyrider, who's a clinical professor of law and co-director of the Center on Wrongful Convictions at Northwestern's Pritzker School of Law in Chicago. She's represented many of the most high-profile cases that resulted in exonerations, and no one has seen this through the lens of clients who have been mistreated than Nora has. Terrell Swift is also with us. He's seen this issue in his own life play out. Terrell is an exoneree who spent 15 years incarcerated for a crime he didn't commit. Having been charged at the age of 17 in a rape and murder, having advocated for himself and reached out to groups while in prison, while also earning an associate's degree, and eventually finding his way to Northwestern Center on Wrongful Convictions, where they determined through DNA testing who the actual perpetrator was, a man with a long criminal history, and eventually were able to secure Terrell's exoneration in 2012. He's been an advocate, he's been an inspiration, and we're so happy to have him with us. We also have with us Cook County State's Attorney Kim Foxx. She's the first African-American woman to lead that office, the second largest in the country, and there's no one in the nation who better exemplifies justice, equitable treatment, keeping communities safe, but by addressing the underlying drivers of crime and ensuring that justice was done in every case. And we have with us to offer international perspectives, Rebecca Schaefer, who leads Fair Trial's Washington, D.C. office, has done work on this issue through publications, through groups she's been part of at an international level, both in our country and throughout the globe, as well as Gavin Oxberg, who's a registered forensic psychologist and a professor of police services, has done incredible work in policing and is a 22-year veteran of the Royal Air Force Police. So let's start this conversation. Laura, talk to us about the history of youth interrogations in the US and some of what have been clearly documented concerns with how we've been doing this for years.
I'd be glad to. Thank you so much, Miriam and Rebecca. Thank you so much for hosting this wonderful event. And thanks to all of our participants for coming in and hearing about this important issue. I want to start by just giving a brief explainer about how police interrogation works. It works according to a standardized set of tactics that are in place across all 50 states, across the United States, and in many countries overseas as well. So here's the way modern day psychological interrogation works. A suspect is generally brought into an interrogation room and isolated from family, friends, outside sources of support. And then the interrogation proceeds generally in two stages. First, the suspect is confronted with assurances that the case against them is rock solid, that they're cornered, that they're trapped, that no one will believe they're innocent. And then the second stage of interrogation provides confession as a way out. Once that suspect is reduced to a place of hopelessness, law enforcement officers are trained to say things like, if you cooperate, people will look at you differently. Maybe we'll be able to get you some help. Maybe you won't have anything to worry about. And in some of the most egregious cases that we see, maybe if you confess, you'll be able to go home. These are the general stages of psychological interrogation, like I say, that are in use across our country and the globe. And what's interesting to me as I sit here in Chicago at Northwestern University is that these sets of psychological techniques were actually developed here about 75 or 80 years ago. You see, before then, before these psychological techniques were developed, police officers around the country were trained to use physical techniques. That was just how interrogation happened. It was called the third degree. People were hung outside windows until they'd confess. Guns were held to their heads. They'd be roughed up, beaten up inside the station house. And about 75 or 80 years ago at Northwestern, a group of then reformers said, you know what, let's get rid of those physical tactics. Let's replace them with instead these psychological techniques, which at the time were thought of as very enlightened, right, and very progressive. But here's the thing. Of course, these techniques are better than physical abuse, but they're still in use, almost untouched 80 years later. And a couple of really important things have happened during those 80 years. The first one, of course, was the development of DNA evidence, right? In the late 80s and early 1990s, DNA technology was invented that allowed lawyers and scientists and researchers to begin testing the validity of confessions that were obtained using these psychological techniques. And what was learned through the use of DNA testing was that confessions obtained through psychological tactics, they turn out to be false far more often than anyone had ever imagined, and under circumstances differently than we had previously thought could cause false confessions. right? So that's one thing that was a huge breakthrough, DNA testing and the revelation of hundreds and hundreds and hundreds of false confessions. The second big thing that's happened over the past really 25 years or so is that in response to this revelation that false confessions were happening, states across the US have begun implementing laws and statutes, starting again here in Illinois, requiring police interrogations to be electronically recorded in their entirety. The idea being, if false confessions are happening at this astonishing rate, we need to peer inside the interrogation room. We need to open that door, pull back the cloak of secrecy that hitherto had been in place, and really understand what's going on inside the interrogation room that can cause people to falsely confess to crimes they didn't commit, right? This counterintuitive act. Why is this happening? And here's what we've learned from that research. We have learned, first of all, that there are certain interrogation techniques that are risk factors for false confession that we see over and over and over again in false confession cases. And paramount among those techniques is deception. You'll recall that when I described interrogation, I talked about this process of telling a suspect that the case against them was rock solid. Well, here's the thing. Police in the United States are allowed to lie about the evidence against a suspect during interrogation, even when that suspect is a child. So you'll see false confession cases in which people are falsely told that their DNA was found at the crime scene or their fingerprints were found on the gun, when that's not true. And that kind of lie is a pronounced risk factor for false confessions, right? So we identified this technique as a risk factor, but there are also vulnerabilities involving the nature of the person who's being interrogated. That was also identified as a risk factor. We know, for example, that youth are categorically more likely to falsely confess than adults. Youth are between 2 and 3 times as likely to admit to crimes they never committed when they're subjected to these deceptive psychological interrogation techniques. We know that's because of the way the adolescent brain works. We know that adolescents are caught in a stage of brain development where they prioritize short-term rewards over long-term risks and consequences. So to them, being in the interrogation room, being subjected to these techniques, they want to say whatever they need to say. They're primed to say whatever they think they need to say to get that offered reward. Just say you did it and you'll go home. And that's why we see these false confessions happening from youth like Terrell at an astonishing rate. We also, of course, see a pronounced disparity in the interrogation room, in the data set of false confessions when it comes to race. All of us, I think, on this webinar now know that race is a pronounced source of disparity across the entire criminal legal system. And it's so important to have conversations around ways in which we can address that. Here in Illinois, when you look at the more than 100 people here in Illinois who have falsely confessed to crimes they didn't commit, we know that more than 70% of those people were men of color. And that's an important thing to center in this conversation as well. Now, here's the last bit I'll say about this landscape that we're now faced with, this new understanding of risk factors that can lead to false confessions, right? We are now in an era of reform. And that's part of what I think this group is so excited to talk to everybody about today. Bear in mind that the US Supreme Court has not heard a confession case since 1991, at least not a case dealing with the voluntariness of confessions. So it's up to leaders like those people on this Zoom call, like State's Attorney Kim Foxx, like legislators around the country, to adopt reforms on our own on a state-by-state basis that will reduce the risk of false confession. And I'm so thrilled that with the support of State's Attorney Kim Foxx and law enforcement across the state, Illinois became last year in 2021, the first state to prohibit police officers from using deceptive interrogation techniques on children under age 18, a common sense reform that was backed by law enforcement and that passed our state assembly with bipartisan, almost unanimous support, particularly, might I add, after the legislators heard Terrell's story, which we're so grateful that you're here to share that today with us as well, Terrell. So we're in a moment of reform. The system is moving forward and responding finally to this well-documented problem. And I'm so thrilled to be here to contribute to this discussion today.
Thanks so much, Laura. And that history is so invaluable in understanding how we got here. And so let me now kind of scroll our glance forward to that moment of reform that you talked about and ask you if you can briefly tell us a little bit more, because recognizing, as you did, that the courts aren't going to necessarily be the solution here, certainly not. I think we could all predict the highest court. So what do we hope we would see in a perfect world from prosecutors putting in place in their offices? And are there other examples of state reform that might be worth looking to?
Absolutely. And I would refer folks, I believe the link was dropped in the chat, to the wonderful issue brief that was put together by your group, Fair and Just Prosecution, which contains a litany of best practices approved by psychological expert, leading law enforcement, progressive leaders, as well as impacted people and those of us who are act on the defender bar in this space. Everything from recommending that those under 18 who are being interrogated need both a parent and counsel in the interrogation room, a crucial reform. Video and audio recording of interrogations, which I mentioned before. About 30 states have adopted that reform, but we need more to do it. And I'm so glad you endorsed that in your brief. The use of deception, which I mentioned, that reform is sweeping the nation. After Illinois' leadership, Oregon followed to adopt a similar law. And I'm proud to report that Utah just became the third state to pass a similar bill. It's sitting on their governor's desk as we speak, which is wonderful. There are many possible reforms out there. Maryland, I should say, is in the process of advancing through its legislature a bill that would require counsel for kids in the interrogation room. It would become the third state to so require after Illinois and California. California requires every child under 18 to have a lawyer by their side during interrogation. So there's a litany of reforms. Check out the issue brief. You're on point with best practices around the globe.
Thanks so much, Laura. And I know you mentioned just how persuasive Terrell's story was in being able to propel reform in Illinois. So Terrell, we are so happy to have you with us, and are hoping that you can talk about your experiences in your story and how that punctuates and underscores the need for us to be doing something on these issues.
Well, excuse me. First of all, thank you all for having me. Absolutely. I guess a side note for me, I just want a little bit of history for me. Back March 9th, 1995 is when I was arrested and wrongfully convicted. And when I received a text last week from Laura, she's about this opportunity to speak on this webinar, it kind of brought me back full circle, right? It's like, so with that being said, I am so privileged and so honored to be able to be here to tell you guys my story to impact change. Because for me, that's why I do what I do, to make sure that there will never be another Terrell Swift story. And, you know, I have to say this again to Miss Kim Foxx. Thank you. We wouldn't have, I truly believe we wouldn't have gotten where we got to without the help of you guys. I mean, you show the world that we don't have to look at each other in an adversarial way when we're trying to do the right thing. So whenever I see you, I'm always going to thank you for that. And I appreciate you. I love you for that. Thank you so very. I love you for a lot of reasons, but thank you so much. You know, and I'll start my story. My name is Terrell Swift. I spent 15 and a half years in prison for a crime I did not commit. Back in March of 1995, I was 17 years of age. I was arrested. The Chicago Police Department came to my mother's house looking for me, stating that I was hiding someone out. I wasn't there. I was at a friend's house. So I called my mother the next day just to check in. I called my mother. She told me that the Chicago Police Department were looking for me, stating that I was hiding someone out. I'm like, what? She said, hey, I'm like, I don't know what's going on. She didn't know what's going on. She said, hey, your dad, where in the neighborhood where I was, it was where my father lived. She said, hey, when your father gets off work, go over here and call this officer and find out what's going on. Did just that. Went to my dad's house, called the officers, like, hey, Terrell Swift. Heard you guys were looking for me. I'm here, 5425 South Bishop. Maybe 15 minutes later, officers came by, asked me if they can come in. We let them come in. They laid some photographs on the table and asked me, did I know any of the gentlemen? I said, no, I didn't know any of the gentlemen that they laid the photographs. They laid some more photographs on the table and asked me, did I know any of those gentlemen? I said, I did not. They then asked me if I would be willing to come to the police department. I said, okay, could my father bring me? They said, no. My uncle was present as well. I said, well, could my uncle bring me? They said, no. Well, could they trail you guys? They said, yeah, we're going to the police department on 35th and Low. I got in the police car with the officers. I was then sped off to the police department on 51st and Wentworth after, they told my family that they were taking me to 35th and Low. Wasn't placing any handcuffs or anything. I got to the police station. They put handcuffs on me. I asked the officer, I'm like, what's going on? He was like, it's formality, right? So I'm like, okay, still didn't know, oblivious. Go into the police station. They sit me down at a table and handcuffed me to the table and started asking me questions about this rape and murder. I'm like, whoa, I don't know anything about any rape or any murder. Can I call my mother? I said, no. Can I call an attorney? They said, no. So I'm not sure how long it went, but it went, they were telling me, you guys raped and murdered this woman. You guys beat this woman, pretty much telling me everything that they thought would happen to this woman that passed. And again, I'm sitting there, I'm 17 years old, I'm scared, I'm crying, I'm asking for my mother, I'm asking for an attorney, and it's falling on deaf ears. So, after sitting in this, the part of the police where in the desk area where they were, telling me everything what they thought happened, and telling me, you're dying in jail for the things that you did, you're never going home. I'm like, wow, I'm 17, right? I'm a kid. I'm telling you, I didn't do this. All I can think of is my life, a 17-year-old kid, like I'm dying in jail for what? Then I'm thrown into a room. And you sit there in a dark room, because people always ask, how could you sign a confession to something you didn't do, right? You're a 17-year-old kid, you're just literally being told you're dying, right? I'm processing my life like I haven't done anything. You throw me in a room and I'm sitting here crying, like what? I didn't do this. And the officer comes by and says, hey, I know you didn't do this. These other guys are telling me you did this, but I know you didn't do this. If you work with me, man, I'll get you, you can go home. And it's that easy. I say it's that easy. Not literally that easy, but it's that easy for a grown person to manipulate a child. If you're a parent, you don't have to whoop your parent. You don't have to whoop your child, to get them to confess up to something, right? You don't have to do that. And the psychological torture of telling me that I'm dying and then flipping that and say, hey, I believe you. It's that easy, right? And with that being said, I was lied to, I was, manipulated, and, they were, hey, you're dying, you're never going home. And then the officer says, hey, I believe you. If you work with us, you'll get the chance to go home. And I did that. I unfortunately believed the officer and the things that he was saying. And I unfortunately signed a confession to a crime that I did not commit. But given the nature of the offense, it was a sexual assault. So there was DNA testing available. It was myself and 4 other co-defendants. We all took the DNA testing in 1995, the primitive DNA testing. We were all excluded. Even though with no DNA, with absolutely no physical evidence, to support the false confessions. We were all individually went to trial, and we were all convicted. So I received 30, my other co-defendant received 30, and 2 others received 40. Again, during my time in prison, myself and my other co-defendants as well, one in particular, my brother, Michael Saunders, he was also, fighting for us. He was no longer here, but he was also writing different lawyers and reaching out to different organizations. And it wasn't until like 2009, 2010, where, our prayers were answered. We finally got help from Northwestern. They reached out to us and said, we want to come and interview you guys, about your case. And, when I got the visit from Northwestern, and, I was, excited, just to be able to tell my truth. And I remember when I got into the visiting room to meet the representatives, where my friends now, it was my attorney, Steve Drizzen, Josh Tepfer, and a group of students. And I just started crying. And, Stephen or Josh asked, like, hey, why are you so emotional? And I said, man, I've been waiting 15 years for someone to take a look at my case. And they said, oh yeah, we've looked at it, and it's clear you're innocent. And before we did anything with court, I knew I was in great hands. We, as you explained, we fought, in court to get the DNA tested, because back in '97, it was just the primitive DNA test, and technology came along in the early 2000s, where they stored convicted criminals, convicted offenders' DNA into a CODIS database. And we fought in court to get the DNA tested that was, at the crime scene. And we were able to get a match to a guy who had a violent history against women. He was at the crime scene. He was interviewed by the police at the crime scene. He said he did not know her. He was just, a bad guy. But, with all that, I mean, I'm more, I'm more proud of, what I went through and what I'm doing now. I've been able to, share this story, share my story, and impact the world. And that's all I want to do. That's all. I just want to be able to make sure that this never happens to anyone again. And everyone here, I mean, I'm so grateful to you guys, because you guys are out here fighting for us, and we really appreciate it, because there are so many others in there just like us, that were just like me, that are still in there fighting.
Thank you so much, Terrell, and thank you for, the bravery in sharing your story with us. And I know, I think for all of us, we need to recognize the extent to which we all bear responsibility, and the system needs to be willing, to recognize and apologize for what happened to you, but not let it happen in the future. And Kim, you have been so much a part of solutions, and really have modeled both support for the recent legislation, but also change within your office on this issue and on juvenile justice issues more broadly. So talk to us about that.
Yeah, so first, thank you for pulling this panel together, and to Terrell for your willingness to share your story, which is not done lightly. And as much as he's able to do this and has done it to lawmakers and the media and to others, it's painful. And so I thank you for your willingness to do that in this full circle moment of today being March 9th and the day that you went in. I appreciate your willingness to do that. What's very interesting about all of this, and how my office took a role in wanting to lead the efforts in changing the law here in Illinois, is I had seen Terrell's story while I was an assistant state's attorney supervisor in juvenile court. And his story appeared on 60 Minutes. And my then boss at the time was adamantly opposed to Terrell and his friend's release. And, one of the things that she had said over repeatedly, well, who would confess to a crime that they didn't commit, as though the science, the research, the data that Laura just talked about didn't exist. And so it was critically important to me when I took this office and I inherited the civil lawsuit that Terrell and the others filed, and rightfully so, to say, what do we do about this? How do we make sure that this never happens again? And owning the role that the prosecutor, my predecessor, played in the devastation that was caused to Terrell's life. A prosecutor did that. And so I thought it was incredibly important as a prosecutor in this office, with the history of false confessions that we have here in Chicago, as well as the history that we have of being the first juvenile court in the world, that we had to have an example of what it means to recognize the practices, particularly as it relates to juveniles, needed to change. And so I was incredibly pleased to work in collaboration with Northwestern, with Laura, with Terrell, and lawmakers, and passing the historic legislation last July, which was Senate Bill 2122, which made Illinois the first state in the United States to ban the law enforcement practice of lying to children suspected of a crime during interrogations. And, what's heartbreaking and celebratory is that we were the first state to do that, but that was not even a year ago. And that this practice was so uniformly done, and though we are seeing it spread or reform across the country, it's general acceptance that this practice was okay at this late stage in the game meant that we had to take an affirmative approach on that. And so we worked, again, in a collaborative effort, letting Terrell lead the way by telling his stories to lawmakers. It got support from both chambers. It was, true bipartisan support. Some who, or diehard prosecutors in their former lives, who were very much not on a criminal justice reform agenda, loudly proclaimed that this was the right thing to do. And so it was incredibly impactful, the work that Terrell was able to bring, and sharing his lived experience to bring together that support, that bipartisan support to get this passed. As it relates to our office, again, we recognize that the burden of proof on these cases is always on the state, and that we have an extra responsibility to make sure that the evidence that we are presenting is in fact accurate, that it is done in an ethical manner, and that we are doing everything in our power to ensure, particularly when we're dealing with juveniles, that we're putting every safeguard in place. So that means, if we have a case in which we believe that violations were made, whether that was a lawyer having not been present for a juvenile. And again, Laura talked about some of the reforms that have been made over the course of the years. But ensuring, that we don't wait for defense lawyers to bring motions when we see something like that happening, ensuring that interrogations are recorded, that we have access to that we're sharing that we share exculpatory information timely, at the earliest possible time. And that we have in our office juvenile specialists, in addition to the line assistants in our courtrooms, who this is all they do, and are able to look at the subtle nuances of these cases, to be able to flag those cases in which we may see that there is some behavior by law enforcement regarding the juvenile that we need to address. And so all of this, I will say, again, was illuminated by Terrell's story. I cannot overstate that enough. But the work that we've been able to do, again, in letting Illinois be a leader in reform, even though we were a leader in establishing some of these terrible practices, requires a collaborative approach. And so while we can work within our own offices to make sure that we have those safeguards available, it really was the work that we did with Northwestern, with Laura, and the lawmakers to change the law. There's much more to be done. I think starting here with juveniles is obvious and long overdue, but certainly these same practices that we're continuing to see amongst not only juveniles, but vulnerable populations where we know that these practices continue, the work needs to continue. And that, I believe, prosecutors should be arm in arm in lockstep with projects like Center for Wrongful Conviction, Innocence Projects that exist throughout the various jurisdictions. This is not adversarial. This is something that we absolutely are aligned with. This is aligned with our mission as prosecutors, not simply to convict, but to seek justice. And if in the seeking of justice means that we work with those who also have information or know that practices and policies are bad, we have to work together to do that. This is not work that should be ceded to just one group. As prosecutors who use this evidence, we have an affirmative responsibility to do the right thing in making sure that these practices don't continue.
Thanks so much, Kim. And I think you exemplify in so many ways the difference leadership can make and the tremendous clout of prosecutors. And at a minimum, prosecutors should not be standing in the way of remedying past mistakes. But let's hope that they can go that much further and be champions of the pursuit of justice in partnership with advocates like Laura, like others. Rebecca, you've seen some of those changes happen across the globe. And so if you could kind of widen our lens a little bit and talk to us about how this issue has been playing out in other countries and what lessons there are to be learned for prosecutors as well as policymakers and others in the US.
Sure. Thanks so much. So yeah, the US does stand out as an outlier, not only in its treatment of youth in interrogation settings, but really in its approach to interrogation for everyone, adults and kids. The rights that we're talking about that are popping up at state level now to ban deception in interrogation, to have counsel present at interrogation, they're the law for everyone, for adults and kids across the European Union, in Australia, New Zealand, and in many other countries. And then in addition to those baseline rights for kids, you have additional rights like the right to have an independent child welfare advocate there in the room with them, the right to an individualized assessment of their cognition and maturity and medical examination before interrogation can take place. These extra rights for kids derived from international legal instruments that the US hasn't joined and therefore hasn't learned from, like the Convention on the Rights to the Child, which we're the only country in the world besides Somalia that hasn't signed, and a number of other legal instruments that I won't get into here. We're also, as Laura mentioned, the only country that I know of in the world that ratifies legally the use of deception and interrogation. So obviously that gives rise to the need for this legislation banning the use of deception, but it's really the floor. It's not the ceiling of where we should be at with interrogation reform. And what we see as a result of our poor legal environment, our poor legal regulation of interrogation, is this reliance in the US on very poor practices of interrogation that have been long discredited in other countries. These kinds of tactics that Laura was talking about. You may know about the Reed technique, which uses these discredited practices like isolation, confrontation, threats, promises, good cop, bad cop, that Terrell described, that we know from decades of psychological research leads to false confessions and false testimony. And in fact, the experts know that too. So the Reed and Associates, which created the Reed technique, actually has a different curriculum that they sell to foreign police forces where they're not allowed to use deception. So they know better, and they do what they do in the United States because they can get away with it because of our poor legal environment and our bad investigative outcomes. Our poor clearance rates, our high rates of wrongful convictions are a direct result from that atmosphere of poor regulation and therefore poor practice. In other countries, like we hear about from Gavin, like England and Wales and like Norway, you have full codes of practice in primary legislation that regulate every step of what police officers can do in an interrogation, in an investigation from the outset. So you don't have police sort of doing whatever they do and asking for forgiveness, maybe later in court. It's regulated from the outset. Unfortunately, our law is decided in this post hoc way, and courts haven't been very helpful or perhaps not very knowledgeable about the kinds of practices that we know are coercive and unreliable in other contexts. And it turns out the constitutional bar for behavior in interrogations, police behavior in interrogations is pretty low, according to most courts. So for comparison's sake, I just wanted to read you out a couple of words, just a few sentences from legislation from other countries. This is like a rough translation of some Norwegian law. It says, during the interrogation, the official must always act calmly and considerately. Promises, incorrect information, threats, or coercion must not be used. During the interview, the suspect must not be told that the charges will be reduced or that he'll be released if he confesses or provides other important information. In the UK legislation, which Gavin will talk about in more detail, it says no interviewer may try to obtain answers or elicit a statement by the use of oppression. No police officer should at any time do or say anything with the intention of dissuading any person who's entitled to legal advice from obtaining legal advice. And here's the language on juveniles. Although juveniles or vulnerable persons are often capable of providing reliable evidence, they may, without knowing or wishing to, be particularly prone in certain circumstances to providing information that may be unreliable, misleading, or self-incriminating. Special care should always be taken when questioning such a person, and the appropriate adult should be involved if there's any doubt about a person's age, mental state, or capacity. Because of the risk of unreliable evidence, it's also important to obtain corroboration of any facts admitted whenever possible. And that's in the primary legislation. So you see how far we are from practice elsewhere. And the research we see on how to, not just on what causes false confessions, but on how to conduct effective interrogations with kids, with people with cognitive differences, with anyone really, has come a long way in recent years. Much of it coming out of these jurisdictions, like England and Wales, like Norway, where the legal regime is stronger, and therefore police have had to develop better strategy in order to comply with the law, when the law no longer allows them to use these coercive and deceptive practices. There's been a huge leap forward in this area internationally with the development of the Mendez principles, which were just published in May. It's a set of international norms on the conduct of interrogations. It's based on law, on science, on ethics. It's currently being considered for adoption at the UN. It's being incorporated by the UN police, and it's being implemented by domestic governments all over the world. Gavin and I helped to write them on the steering committee, led by the former UN Special Rapporteur on Torture, Juan Mendez, together with other, not just human rights lawyers, but former investigators and police like Gavin, and psychologists from all over the world who are expert in the science of memory and recall. So now we have these international guidelines that I'm going to link them after I stop talking. We have these guidelines that really set out why and how humane rapport-based techniques and the integration of legal safeguards into the interrogation not only protect people who are being interviewed, but also produce better investigative outcomes. That's really the fundamental insight of the Mendez principles, that the legal safeguards like right to a lawyer and right to humane treatment and freedom from deception are completely compatible with, and in fact necessary to, an interview that's going to lead to testimony that's accurate, that's reliable, and that's admissible in court. So this is all just to say that banning deception is really just the beginning. It's just a baby step, but a really, really important and necessary one to catch the US up with law enforcement standards internationally. Thanks.
So thanks so much, Rebecca. And I think if people take anything away from this, it's hopefully the extent to which we are an outlier and we can look to better principles elsewhere. Again, I would also encourage folks to look at the model policy that's in the FJP issue brief that really defines very clearly and succinctly 6 specific areas where changes are needed and where DAs can put changes in place just simply with the stroke of a pen, or where legislators or policymakers can put changes in place by virtue of legal requirements. Gavin, talk to us about the journey that the UK went through. So you saw as a police officer up close that process of change, and you also saw a process of change for you and your colleagues as law enforcement officers. So give us a sense of that before we open it up and try to field some of the questions.
Of course. Thanks very much, Miriam. And thank you so much for inviting me to this excellent webinar. And Terrell, your story that you mentioned, if anybody's in any doubt why things need to change, you know, you're an excellent role model for that. And we need to change things if we can. But certainly within the UK, I know you know this, but it's split into England, Wales, Scotland and Northern Ireland. And every one of those sub-countries has their own rules and regulations, which makes things slightly difficult. And As Rebecca said, within England and Wales, we've got various various rules and regulations. We've got the Police and Criminal Evidence Act of 1984. And if you're interested, codes C and E predominantly are the ones that you want to look at. But also for juveniles, we've got the Child and Young Persons Act, and we've also got the Youth Justice and Criminal Evidence Act. And obviously for suspects, we have our PEACE model of interviewing, which is a framework for interviewing all types of suspects. And for children, as victims or witnesses, we have the Achieving Best Evidence document. The age of criminal responsibility in England and Wales is 10, and after, from 10 years onwards, they're treated as almost as an adult for any crime that's committed. And obviously, when this came out, the 1984 Act came out. Prior to that, we were trained in techniques akin to the Reed technique of interrogation within England and Wales. And when the PACE Act came out, it got enacted around 1986-ish. There was a lot of issues and a lot of problems with a lot of law enforcement officers who didn't like the idea of people being able to listen into our interviews, having them audio recorded, being able to analyze the interviews. And between 1984, 86, and then up to 1992, when the PEACE model of interviewing came out, there was a lot of poor interviewing practices that we realized needed to be changed. And that's when the PEACE model of interviewing came out. And again, there was a lot of issues around what we were doing and why we were doing it. And I certainly was taught as an interrogator pre-1984. I joined in 1982, where issues that others have mentioned around the third degree, quite coercive tactics were used on a regular basis. And I can still remember various incidents where some of my colleagues would come in with fire extinguishers and threaten to set them off with the suspect. It was, looking back, it's quite frightening. But nowadays, and looking back to what we used to do, it's embarrassing, it's shameful. And I'm glad we have what we have in now. And I think if anybody ever said, would you ever go back to what we used to? The answer would be a resounding no. We have moved on. It did cause some issues to start with, but it was very quickly resolved. All officers were trained in PACE and the PEACE model of interviewing, and without much problems at all, after a couple of years, all officers were trained, and we are absolutely fine, and we'd never, ever go back. And I think just to finish off as well, in terms of suspects for juveniles, we can only hold them for a maximum of 24 hours before we need to either charge or release. That can be increased up to 36 hours or a maximum of 96 hours with authority. It could be a superintendent or a magistrate, but the juveniles cannot be held, or anybody cannot be held incommunicado. They must be given the right to have somebody notified of their arrest. As Rebecca said, all children must have, or all juveniles must have, an appropriate adult present. And even if the juvenile waives their right to a legal advice or legal advisor being present, the appropriate adult can insist and can actually overrule the juvenile. And in terms of the rest periods, within any 24-hour period, they must be given 8 hours rest, continual rest, which I think is a real good thing. And we'd never ever interview one person for more than about 2 hours without giving a break. That changes depending on what the offence is. If it's a terrorism offence, that they can detain them longer, can interview them for longer, but in general practice, within any 24-hour period, 8 hours rest, and no more interviews that last up to 2 hours, and that's it. So thank you very much.
Thanks so much, Gavin. And I so appreciate your underscoring that it's not simply the importance of kids having a lawyer, but it's the need for a lawyer and a parent or guardian. It shouldn't be one or the other. And in fact, those are that we do see in place in other parts of the country, just as we see the importance of conditions of interrogation, how long it goes, the importance of breaks, all things, again, that are set forth in the model policies in our issue brief, and the need to video and audio record. I think Laura's out that it was only when those things were happening that we started to see some of the real problems going on. Just as our issue brief tries to define what would youth-friendly Miranda warnings look like. We know that Seattle's police department and other parts of the country have been looking at how do we craft the type of warnings to young people that will really be understandable and consumable to them? And how do we recognize that below a certain age, as New Mexico has done and others have been talking about, we simply shouldn't presume that any statement could be deemed voluntary and used at trial. And for individuals above that age, there should probably be a presumption of unreliability unless and until confessions are corroborated, which very much goes to the question that was asked about, why do we rely on confessions so much? Why are they such a linchpin of cases? And I'm curious if any of you want to weigh in on that, you know, whether Kim or Laura, you may have impressions, but, you know, how do we move away from that starting point in the first instance?
I mean, listen, I think for some people, as I said in my predecessor, who could not fathom that people would admit to things that they didn't do, it just felt, I think, natural that if they said that they did it, then they did it, right? There was this disbelief that someone facing very serious consequences would put themselves in harm's way. And, you know, the fact of the matter is that we know better. And I think for many of us who do this work, and I shouldn't say we know better blanketly, I think there are still large swaths in law enforcement who don't believe that, who believe that they are unbreakable, that, you know, no one would admit to doing something that they didn't do. And that despite, you know, I have 4 teenagers I live with, I know that they say things that are just not true, depending on the moment, to get out of a temporary bit of trouble. And the things that you say to them can coerce that. And so I think the point that was made earlier, like, what is the corroboration? Not relying on statements by the defense alone or defendant alone helps eradicate that. And a lot of the cases that we've seen where we have vacated convictions in our office during his tenure that have been based solely on a confession, the question you asked is, how did we get here in the first place without any corroboration whatsoever and without any thorough interrogation from the prosecutor side of how the confession was garnered? I should also say, before I turn over to Laura, you know, there was some complicity. It wasn't in our office as it relates to Terrell's case. You know, the prosecutor's office was aware of the practices that were happening and participating in those practices. And I think we have to be honest about that this was not simply a policing tactic. It was a tactic that was signed off by the prosecutor, who knew the stories that were being fed, who knew where the holes were, who knew where these young men were being led to, what they were being led to say. And so I think we have to be honest that the cutting of corners that happened so much more prevalent and obvious in the 80s, 90s, and early 2000s was because it was easy. Because if the goal is convict, it was convict by any means necessary. And that's just an honest reality of where we were in prosecution.
So Laura, I want to turn it over to you, and then Gavin, I'm going to ask you to chime in and also perhaps talk about training of police that was asking the question. But Laura, when I turn it over to you, I'd also maybe like to have you address a question that came up about the question of accountability. You know, what are we doing to not simply avoid these problems moving forward, but also to think about accountability, whether for prosecutors or others who are involved, and perhaps creating teachable moments where there's systemic accountability. So we are learning from past mistakes and not repeating them over and over and over again.
Sure. Well, I'll just start by building off of what State's Attorney Foxx said and then move to the second subject. You know, Terrell's case is so very much not unique. And I want to underscore the part of his story in which he described the fact that in his case, there were multiple confessions. And before trial, DNA, very probative DNA evidence was tested and excluded all of them. Yet the prosecution at that time in the 1990s moved forward. It was a battle between these two titans of evidence, right? The confession and DNA. And in Terrell's case, the confessions were the thing that were trusted, believed by the jury that resulted in the conviction. His case is not alone. There's a whole litany, a long list of cases in which confessions were disproven even before trial. by DNA evidence. And yet the prosecution at that time went forward based on the confessions alone because of this belief that you described, State's Attorney Foxx, which is this belief that no one would ever confess to a crime that he or she didn't commit. We now know, because we are trusting the science and where it leads us in these cases, we now know that confessions really are like just another piece of evidence, right? Confessions are just another piece of evidence. They're capable of being contaminated. Just like scientific forensic evidence can be contaminated in the lab, confessions can be contaminated by interrogators who coerce suspects, who release details about the crime scene to suspects during interrogation, so that an innocent suspect might be able to incorporate those facts into his or her confession narrative. So that's a huge part of the conversation that we're having right now, is demythologizing confessions, understanding them as simply another piece of evidence to be weighed in the mix of good judgment making and good decision making on the part of prosecutors who seek either to drop charges or to press forward with charges. And on that point, I think the most important takeaway that we can all experience together and take away from this conversation today, that when we think about moving forward, accountability is an important part of that conversation. Working to compensate people for those years lost and the time that they've lost is crucial and just and right. But the most important thing, I think, in a global sense, is to bring together conversations just like the one that we're having today, that bring forward different parts of the criminal legal system, from impacted people to prosecutors to defenders, global perspectives, the folks that we have in the audience who are contributing their own stories. It's these kinds of dialogue and shared learning moments that will and are moving this space forward.
Terrific. Thank you so much. For Gavin, I'm going to give Terrell the last word, but before I do, just want to get your thoughts on this issue and the question of training.
Yeah, of course. And I wanted to say as well that unfortunately, I was one of those very naive police officers in the early to mid 1980s that believed that only an innocent person, only a guilty person would confess to a crime. The innocents wouldn't do that until it happened to me. And I was actually interviewing somebody, probably more of the interrogation side, not coercively, not horrendously in any way, but somebody confessed to a crime, and I found out a week before the military courts martial that that person hadn't committed the crime. He just believed, because of the evidence I'd presented, that he must have committed the crime. So as you can imagine, that's what started me off in my route to being a psychologist, because I thought, how on earth could I get somebody to confess to a crime they didn't commit? And that opened the whole world of psychology, false confessions, etc. So if anybody's out there that doesn't believe that you can get a false confession from somebody, you can, and it does happen. But certainly in terms of training, the training that police officers in England and Wales get, I can't speak for Scotland and Northern Ireland, but in England and Wales, they get normally a week's solid training on interviewing suspects and a week's training on interviewing victims and witnesses. If they then go on to become a child protection officer, it's another 2 to 3 week training course on how to interview children and other vulnerable persons. And within that, we also have something called registered intermediaries for any victim or witness who is vulnerable in some way, where we can actually get a qualified registered intermediary in who can actually advise the police on how to conduct the interview, but more importantly, can actually sit through the trial with that person if it's, if they're giving evidence in court, and they can actually stand up and tell the prosecution or the defense not to ask questions in a particular way. So all this is trained to the police officers over a number of weeks.
Thanks so much, Gavin. And I know there's a lot more there, and that we are reaching the end of our time together. Terrell, want to give it to you for a quick last word to folks.
Yeah, I just wanted to, just touch on the importance, like the importance of just getting it right, in so many aspects, on so many levels. This case affected my life, my family's life, the victim's family's life. It's like, you want to do the right thing, right? As an officer, you want to convict the right person. As a prosecutor, you want to prosecute the correct person. I just have to make mention, it's like, this guy, he continued to stay out and continuously committed more crimes in the neighborhoods. And I just wanted to stress that, you know, this is why this is so important. Because again, like I said, just bringing that awareness and that togetherness that's needed, because we shouldn't look at it in a combative way, because we just want to do the right thing. We want to convict the right person. We want to prosecute the right people, and we want to give closure to the family as well. We definitely can't neglect, you know what I mean, the family, because, you know, my heart goes out to the family in my case, because they thought they had the case solved in 1998 and then have to reopen that wound. That's tragic. You know what I mean? So we just want to get it right. And, you know, I'm thankful we're on the right path, but listening to Rebecca and Gavin, we are so far behind.
We are indeed. And Terrell, thank you so much for that. It really is that easy. We don't simply want to get it right, we have to get it right. And we owe it to our community to get it right. We owe it to the next Terrell, we owe it to victims and survivors of crime, we owe it to everyone who is part of the criminal legal system. So I want to thank again our panelists for joining us. We have a roadmap for how to get it right. Encourage folks to look at our issue brief, to the other resources that are available. A recording will be circulated after this event. If you want to share it with others, we'll also be on the Fair Trials YouTube page. And I want to do a shout out to the wonderful team at FJP, Natasha Kami, Monica Furman did amazing work, Alyssa Kress, so many others. And again, thank you to our panelists for sharing and for offering us the way to get it right. So see everyone soon. Bye-bye.